That's the wrong weekend to go away. I'm landed up. Apparently it's the best of it. Afternoon, everyone. Thank you. My name's Sebastian Hartley.
And I'm Sophia, and welcome to the Public Law Test Workshop for this year.
Thank you to A.U. Alessius and Russell McVeigh for their support.
So first we just have a little disclaimer. We just want to say that this workshop is based on our personal experience and our own opinions. Obviously we had different lecturers to you guys, so they would have used different cases or used them slightly differently to illustrate their points. So if you're in doubt, always go with what your lecturer says, because they will be the ones marking your test. Also, just be careful if there have been any changes in the law for this year, but they would have probably let you know about that. Also, just a note about the usefulness of sources. Most of your knowledge should come from your lecturer, your textbook, and from making your own notes. And so this workshop and any tush notes that are floating around are probably not the best source to base all of your study off. So what we'll cover today, we'll be doing just some general tips, because we know that for many of you it's your first Part 2 test. We will go through some content, and then we will go through a practice question and from last year, and we also have an extra question and answer that you can go through in your own time. And don't worry about trying to get all of this down, because we will put the slides up for you on the Part 2 page, so you can just sit and relax and listen. So first, some tips. So this is an open book test, which means that you can take in notes. Everyone will be different, but how I did mine was I made one detailed set of notes, and that just had all of the cases, basically like case briefs, but the most important thing to get down in those are obviously the ratios, all the legal principles, any dissenting judgments as well, and probably just 1 to 2 sentences max of facts, because those are not as important. And then I also had a condensed set of notes, which was basically just templates or a summary. And because it is such a time-pressured test, you basically don't want to be referring to your detailed notes and trying to flick through them and search them and find some case or some ratio. So just stick to like a summary that you can just go through and tick things off, kind of thing, as you go through. Seb, how did you do your notes? Did you do them the same
My
way,
notes, which I'm sending out, my legislature notes to everybody through the Part 2 page after the lecture, so when in a little bit I cover the content, don't worry if you don't get something, but you'll be able to come back to it. As you can see, these notes are all bullet pointed. This is about the longest you'd want them. This is just a series of propositions of law contained in the authorities and relevant statutes, and any guiding notes about the purpose of something, any principle or policy considerations that my lecturer emphasised. So just you want to have very thorough notes in case you get an essay discussion type question, which you can refer to, but ideally you should not have to refer to your notes at all, but at very best just some bullet points which you can literally copy across very quickly.
also doing past papers is really helpful, and study groups as well, just because when you're in study groups you can obviously discuss amongst each other and sort of argue, and that will, what is it, you remember like 20% of what you talk about, I don't know, with other people, something like that, whatever your lecturers always say to you. And last of all, don't stress, because this test is Plusage, so it's not the end of the world, but it is a good practice for the final exam.
And everybody does better in the final exam. Yeah. We did.
So during the test, read the question, stay calm, take some deep breaths, always take some time to plan your answer, and they also really like it when you use headings in your answer, just because it's easier for your lecturer to go through and mark it. Also make sure that you answer the question and don't just word vomit. And during the test, again, focus on the legal principles. You don't really want to be writing about the facts of the cases at all. When referring to cases, mention the year in court. Also, probably the judge if it's a dissenting judgment. And also, it's really good to say whether they're binding or persuasive. Obviously, make a plan for timing and stick to it. If half the time has passed and you haven't written as much as you had planned, just be more concise, because you always have to finish, and even bullet points are better than not finishing it.
And now we come over to the content side of the lecture. Now we know that most of you have a fairly good grasp on the content, so we're not going to emphasise regurgitating the ratios of the cases for you. I'm hoping to give you a broader overview of how all of the different things you've studied slot together, but it's coming up with that idea of how all of public law fits together as a nexus of intersecting principles that your lecturers will really be looking for if they want to award you a higher B or an A range mark. But if that goes past you for whatever reason for this test, don't worry. There are 3 simple propositions that cover the legislature topic. The first one is that Parliament is supreme. As your lecturers said many times in 121 last year, if Parliament passed a law saying that all blue-eyed babies were killed at birth, we would have to do it, because in New Zealand we have an entirely positivistic approach to the law. If Parliament properly passed a law, that is the law, and there is nothing that can be done about it. The only solution, if you don't like something Parliament has done, is to vote out the government. You will have all covered Cook's dicta in the course of this case, as we think you're probably going to be getting a question on the implied repeal of the fundamental right / retrospective legislation this year. Cook's dicta will be an attractive thing to you to try and argue your client out of the bad situation they will almost certainly be in. Do not rely on Cook's dicta. They are not a good statement of law in this country. They are a speculative and palpably anti-democratic measure. Anyway, those are the essences. Now, as I said, I'll be sending out my notes, so I will be covering 15 hours worth of lectures in the next 15 minutes, so I will be rushing somewhat, so if you don't pick up on something, my notes will be available. You will have covered the concepts of parliamentary privilege, especially freedom of speech in Parliament and contempt of Parliament. These topics very rarely come up in the test, so I won't speak specifically to them. My notes are there, mainly focus on them for your exam. In particular with that, remember that the common law of Parliament and the provisions of the Legislature Act 1908 dealing with those issues were superseded late last year by the Parliamentary Privilege Act 2014, which specifically overturned many of the cases that you covered in class. What is more important is what I just said, the obligation of the courts to give effect to enactment. Section 15, Constitution Act 1986, provides that the Parliament of New Zealand continues to have full power to make laws. This is reinforced by the Statement of Principle in Section 3, Subsection 2, Supreme Court Act 2003. And further, by Lord Reid's judgment in British Railway Boards and Picken, which was adopted into New Zealand law by Burkitt and Tauranga District Court in the High Court. The basic principle is, of course, that the courts, once something has been established to have been passed by Parliament, are unable to go behind the parliamentary record in order to establish anything more. Why is this? It is partly because of the comity principle, that it would be bad for the maintenance of government in order for if the branches of government started arguing over one another and tried to overlap their functions too much. It would also, because of the overriding recognition and deference to Parliament given of parliamentary sovereignty under the common law. The substantive issue, and the one which is probably the most important to you going into this test, because we think it will be on implied repeal, is the traditional review of implied repeal, which states that where Parliament passes a statute at a later date to another statute which is incompatible with the earlier statute, the earlier statute is held to be implied pro tanto, that is to the extent of the inconsistency between them. The assumption underpinning this is the belief that as Parliament is sovereign and enjoys sovereignty on an ongoing basis, a sovereign cannot tell a sovereign what a sovereign cannot do. It's the same sort of logical proposition. I'm sure you've all heard the line, if God can do anything, can God make a hamburger so big that God can't eat it? This was, of course, apparently I'm the only one. The basic proposition for that, of course, comes from Allen Street Estates Limited and Vauxhall Estates from the 1930s in the UK. In both of those, there was exactly that situation. Two incompatible statutes existed. The later one was held to have impliedly repealed the earlier one to the extent of the inconsistency between them. This principle is kind of the foundational starting point for any discussion of implied repeal. However, as you know, this principle has become limited in its application to an extent over time. The main way in which this has been done in a way that a court might actually be persuaded to accept is through the principle of legality developed by Lord Justice Laws sitting in the United Kingdom Court of Appeal in Crown and Lord Chancellor Ex parte Witham and Ex parte Sims. The basic principle of the principle of legality is that there are certain rights and certain statutes which, even though we have no codified constitution here or in the United Kingdom, are so integral either to the functioning of our democratic or constitutional order, such as the electoral system provisions, or the jurisdiction of the courts, or touch on the fundamental rights, such as the fundamental rights that are now partially expressed in the New Zealand Bill of Rights Act 1990. The principle of legality which Laws J advanced was that if a statute contains a fundamental right or a constitutional principle, Parliament will have to speak very clearly in order to abridge that right. He does not, and you should be very careful when you say this, say that there are any limitations on what Parliament can do. It's essentially a way by which the courts have given constitutional protection to significant rights, whilst not directly challenging parliamentary supremacy. It's essentially willful interpretation by the courts. They say, even if it's very obvious Parliament intended to restrict the fundamental right, they're just going to say Parliament hasn't spoken clearly enough. This approach was picked up by two of the dissenting judges from the seven-judge bench in the Court of Appeal in Crown and Pora in New Zealand. Elias CJ implicitly picked up on the principle of legality in her reasoning, which ran to the same effect as Laws in the Crown and Lord Chancellor Ex parte Witham. Justice Thomas, also in Pora, specifically said that with the usual rules of interpretation used by the court to determine intention are arrested where fundamental rights are concerned. His Honour did not, however, cite any specific authority in support of this point, so don't rely on him. Law's thinking was most clarified in Thoburn and Sunderland City Council in 2003, which came after Pora, which I think you should make clear in your answers to show that you understand that in Pora they weren't referencing Thoburn. The same principle referenced in Pora came across more strongly in Thoburn. It's those sorts of little distinctions that your lecturers, if you're on a borderline, will probably use to push you over the mark by showing your deeper understanding of the law. The other aspect of implied repeal of fundamental rights comes under Cook's dicta, which, as I've said, should not be relied upon because they are not a good statement of law, and no court is ever going to pick up on them because doing so is directly against the parliamentary sovereignty principle, which the courts have affirmed as the basis of the constitutional relationship, and also ensuring that in our popular sovereign democracy, the people remain sovereign rather than unelected, unrepresentative judges. Most of your lecturers, even the most rights-conscious amongst your lecturers, will accept that Cook's dicta are very poor from a policy justification because they are anti-democratic. And that's something which I think came across as a surprise to both of us last year. Public law, unlike your examples from 131 last year or your studies, I assume most of you are doing crim alongside public. In crim, as you know, it's a very black letter law subject, very mechanical. The basic thing in public is that this is probably the paper where you'll have the most scope to adopt a political, philosophical approach to your studies. They want you to have a solid conceptual understanding of the principles of constitutionalism underlying the principles. So when I say that the fundamental tension inherent in the implied repeal question is between granting some recognition to fundamental rights which we regard as being highly important to our sense of individual liberalism, which underpins our whole constitutional order, against the recognition that Parliament, as the representative of the people as a whole through the electoral process, needs to be able to pass whatever laws the people it is obliged to represent want. This comes down to the same debate, which I will discuss when I discuss the entrenchment section in a moment, of whether constitutional flexibility should be adopted at the expense of being able to underpin certain things as of being of continuing importance. As you know, the basic preposition in Cook's dicta, the cases of which are Allen and Brader and Ministry of Transport, NZ Drivers Association and NZ Road Carriers, Fraser Interstate Services Commission, and Taylor and New Zealand Poultry Board, is contained in the dictum, some common law rights presumably lie so deep that even Parliament cannot override them, the essential preposition of which is of course anti-democratic and goes against the very fundament of parliamentary supremacy. The other side of questions that you will generally be asked in the test, and we don't think this will come up, but it's important that you study it in any case because there is no obligation, as Sophia will discuss in a moment, for them to break it down as they have done, but they have no reason not to either. The entrenchment is, of course, as you know, the procedure by which Parliament dictates that some special procedure will be required in order to amend a statute or execute a certain legislative process. There are two concepts. One of them is single entrenchment, such as seen in the Electoral Act 1993, section 215, I think, which provides that in order to change a certain section, the one which says that Parliament lasts for 3 years, Parliament has to either adopt a 75% majority or a simple majority in a popular referendum in order to change that law. However, it's not doubly entrenched. It would be doubly entrenched if the entrenching provision was also itself subject to entrenchment, which means that Parliament could, through a two-step approach, repeal the entrenching provision, then repeal by simple majority 3-year parliaments, meaning that if in one party ever secured a majority, assuming party discipline held, any party could theoretically cancel all elections for the rest of time. Which obviously, as you know, since we have an executive-dominated legislature and no constitutionally protected rights, means that the only effective way to get rid of a law in election would be gotten rid of. There is very limited case law in New Zealand on the concept of entrenchment. Your three main authorities for the possibility of effective entrenchment are Attorney General of New South Wales and Trithoan, Harris and Dongies, and the Bribery Commissioner Andrana Singhay, the facts of which are basically all that these were colonial legislatures. The imperial legislation which constituted them said that you could have effective entrenchment, and the courts applied that provision. These are all totally distinguishable from New Zealand on the basis that our Parliament is sovereign. Any law which you would be dealing with would be dealt out by Parliament, and therefore the proposition that a legislature cannot violate in violation of its constitution wouldn't apply. This Parliament determines what its constitution is because it's an ongoing sovereign legislature. The only New Zealand authority which suggests that the courts have jurisdiction to determine whether there has been compliance with any mandatory manner and form requirements imposed by statute law for the enactment of legislation, is the decision of Justice McGeechan in Westco Lagan Limited and Attorney General in the High Court. The assertion is problematic. for the reason that, firstly, because it says that Parliament can bind itself, which of course violates the concept of sovereignty. The problem is that he says that because it's the court's job to uphold the law, and because somebody has to be able to uphold the law, the court should be able to uphold laws giving effective entrenchment. This reasoning is, of course, circular. He is assuming that entrenchment is an effective law in order to prove that entrenchment is an effective law. He does cite some authority, which is Section 3 of the Declaratory Judgments Act, which provides that courts can assess the validity of statutes. However, that provision was enacted while Section 53 of the New Zealand Constitution Act 1852 Imperial was enacted. This provision was analogous to all of those like Intrathrowan and Harrison-Dongies, which was imperial legislation constituting the legislature. The problem is, of course, is that that's now been superseded by the Constitution Act 1986 and the Westminster Statute Adoption Act 1947, meaning that it doesn't apply. His Honour did affirm, despite all of the speculation, that ultimately you still need to go to the electorate anyway. The other authority is Jackson and the Attorney General, which talks about the redefinition of Parliament for different purposes, which is the analysis of entrenchment that properly will work for you, which basically was a case where the lower house of the bimarcarial legislature in the United Kingdom passed an act saying that it could pass laws without the assent of the upper house under certain circumstances, and it was held that, despite some objections, they could allow for the procedure to be passed. So there was comment that certain fundamental laws of constitutional and rights laws mightn't be able to be passed, but they didn't dwell on that, which would lead you towards a Cook's dicta type analysis. The other sections are the interaction between international law and New Zealand law, the basic proposition of which is that you need to know that the courts will assume that Parliament has legislated consistently with New Zealand's obligations under international law, even if those haven't been formally adopted into New Zealand statute, because of course we have the dualist approach, which means that you have to pass international law into domestic law. This was seen in Te Vita and Minister of Immigration, Sellers and Maritime Safety, Inspector Anzawi and Attorney General. Anyway, people are starting to yawn, so I'll shut up. That's the course in a nutshell. These notes will be going up, so I know I talk very quickly, but thank you for paying attention. And now Sophia will tell you what you came here to really find out.
So, thanks, Seb. Seb is pretty much a walking Joseph's textbook, so
which
that's
you shouldn't
very
rely
lucky. So before we get stuck into the practice question from last year, which was on entrenchment and manner-informed provisions, so that's why we think that you guys might get a inconsistency with fundamental rights question. I just want to make the point that even though you shouldn't rely on things like Cook's dicta, you should still mention them and then again make the argument why they shouldn't be relied on, because that's what they want to see. They want to see you distinguishing cases, and they also want you to be arguing by analogy. So, and if you can argue for both sides, and then adopt whichever one you prefer at the end and do it persuasively, that's what they want. There's no sort of correct answer as long as you argue your points persuasively and argue for both sides. So, and also don't worry about writing stuff down, because we're recording this. We're going to put the slides and notes up, so don't be stressed out at all. So this was the question from last year. Excuse my scribbles on it. So we can see here that there was a single entrenchment of the New Zealand Bill of Rights Act by Parliament in 2014, where they passed an amendment saying that, with an 80% majority, saying that no provision shall be repealed or amended unless that amendment is passed with a 75% majority or by a majority of the public in a referendum. that amendment also repealed Section 4 of the New Zealand Bill of Rights Act, which, if you guys remember, is the section that states that any other statute will prevail over the New Zealand Bill of Rights Act if there's an inconsistency. So basically, it makes the New Zealand Bill of Rights Act subordinate to any other statute.
Supreme to any other state. But
Section 4, yeah. And then, so that's basically all you need to know there. And then in 2015, Parliament passes another statute with 53% majority, so doesn't meet the requirement, that expressly prohibits all media reporting of commercial litigation in the courts and expressly states this intention notwithstanding the New Zealand Bill of Rights Act 1990. And then it is accepted by everyone that this is inconsistent with Section 14 of the New Zealand Bill of Rights Act and cannot be brought in under Section 5 of the New Zealand Bill of Rights Act. So basically it is the issue here is will the courts uphold entrenchment as effective, and will they hold the inconsistent 2015 Act invalid? And also, where it says you should not consider any possible arguments on the basis of breach of fundamental common law rights based on the dicta of Lord Cook, that's basically just a hint that it is a question that is more focused on manner and form provisions instead of sort of more substantive content, which is what you'll get in a fundamental rights question. So this was, and I'm just going to go through my answer. So first things first, you state the issue, and usually it will phrase the issue for you in the test paper, so basically you just write it out. Also, usually it asks you to advise someone, so it's always good to get you on the right track to say that, you know, I'm asked to advise someone as to whether, like, okay, so this is, just start off by saying that, as Seb said, the power that the New Zealand Parliament has to bind itself as to manner and form requirements has not yet been tested in the courts. As the traditional Diceian view sees entrenchment as inconsistent with parliamentary sovereignty, as parliaments are equally sovereign and one cannot bind another, so that is the traditional orthodox position. In a lot of these essays, the structure will sort of unfold for you because you can start off with sort of these traditional orthodox prepositions and then talk about how the law has developed. So that gives you sort of a structure to follow. However, recently I mentioned that the courts have become more willing to look at manner and form or procedural requirements as seen in Jackson. And in deciding whether to uphold entrenchment, the courts are likely to take into account factors such as the extent to which the requirements intrude on parliamentary sovereignty, as well as their quasi-constitutional character. So if it's something to do with voting rights or the term of parliament, the courts are more likely to want to uphold that. So again, as Seb was talking about, there have been those 3 cases in the common law jurisdictions which have upheld these entrenching provisions. So that's arguing for entrenchment. And then you're going to show that you're really smart and say that however, they can be distinguished because, again, they're from these colonial legislatures where the original legislature put in the sort of gave the Parliament the power
constituted them, and in all of them there was a provision which said that they had to follow manner and form requirements specifically.
Yeah. So, in contrast, it's not the case in New Zealand because Parliament is sovereign and not subject to any constitutional legislation. Yes, moving along. And then you could, for arguing that it could be legally effective in New Zealand, you could talk about how manner and form requirements were followed when MMP was introduced. You can talk about the Bill of Rights white paper, which suggested that the courts are likely to uphold entrenchment of a Supreme Law Bill of Rights if it was passed by a special majority of 3/4 of the House. And also probably your most important case is Wesco-Lagan, which again stated that the courts would uphold manner and form requirements if standing orders were adhered to. And also, I mentioned that entrenchment would require a procedure that would convince later courts to give effect to it. In this case, it was passed by an 80% majority, and it also protects fundamental constitutional rights. However, if there was a case where a small majority tried to entrench a provision that would have to be passed by a much larger majority, it's less likely. Also, if they put in place like a completely ridiculous requirement for like a 95% majority to repeal or amend the entrenched provision, then as you can see that's obviously undemocratic, so less likely to be enforced.
And if you're looking for some authority for that argument came out of a speech Lord Cook gave speaking extrajudicially sometime in the late 80s, which your lecturer will be able to point you to if you want to follow that.
See, there we go. Like, amazing. And then it'll be, obviously you want to argue the other side, so you're going to argue about why it could not be legally effective. And then you can go back to the orthodox view, that if it's recognised as effective, one parliament is effectively tying the hands of future parliaments. And this is supported in Vauxhall and Allen Street Estates. Yes, moving on. And then you can go back to discuss the self-embracing new view of parliamentary sovereignty, which tried to reconcile manner and form requirements with parliamentary sovereignty, and this can be seen in Jackson. This states that the definition of parliament is logically prior to the constitution of parliament and has evolved out of common law decisions, and that parliament, being sovereign, can redefine itself. Jackson ruled that parliament can be defined differently for different purposes, and that subsequent laws that don't observe the correct procedure are not laws at all, and the courts cannot recognise them as such. Again, you could, Jackson will probably be your most reliable authority for that, but you could still distinguish it by saying that in that case they were making it easier to change the law instead of harder, and also obviously coming from the UK, you could argue that the situation in New Zealand is different.
And in particular, an argument which would quite impress your lecturer if you mounted would be that because in the UK that procedure was passed to allow the popularly elected lower house of their legislature to overwhelm obstruction from a less democratically legitimate upper house, you can argue that's a very different proposition to saying that one sovereign parliament should be able to overwhelm another equally sovereign later parliament, and of course this argument is wholly political, there's no real legal basis for it. But if the Supreme Court was asked to rule on this matter, it would have to look to such factors to come to a determination.
Yeah, and just to reinforce, the fact that there is no right answer. Me and Seb had came to completely different conclusions. I said that it was likely that it would be enforced, and Seb said that it wasn't. And as you can see, it doesn't matter as long as you argue sort of both sides and show that you understand like the more subtle, fine points, I guess, and use all your skills from 131 legal method as well. I'd like to see that. So yeah, that's what I concluded, and I basically said that parliamentary sovereignty still reigns supreme as Parliament remains free to amend or repeal the provisions with the required majority. And so we also have, we've run out of time, but we also have an exam question on inconsistent legislation which takes away fundamental rights. So that's like a substantive content of the law question as opposed to a manner and form question.
This is what we think you'll probably be being tested on.
Yeah, and so we'll put the slides up and you can go through the question and a possible way of answering it. Again, don't stress. The test is plusage. It is just a good practice, and afterwards, we think that you should all head down to Shadows and relax. Anyway, thank you guys.
Well done, guys. I think whether you guys got copies for yes.
Oh, we did. We just did okay in the test.
So, well done.
Thanks a lot.
Lawrence, best of luck.
I'm sure I was doing my 299.
I know.